Hello, everyone, and welcome to a new session with the Rights and Responsibilities Awareness Initiative. Today, we're lucky to have Megan Jenner, a partner from Cohen Highley LLP, to talk to us about estate planning essentials. Megan, thank you so much for being here with us tonight.
No, thank you very much, and welcome everyone. Thank you for coming to our discussion this evening. So I'm Megan Jenner. I am a lawyer at Cohen Highley, and a large part of my work focuses on wills and estate planning. So this includes guiding my clients through the preparation of their wills and their powers of attorney, and making sure that their wishes will be executed when they pass away. And for a lot of people, talking about and planning for your own death can be really uncomfortable. But this type of planning process is really important if you want to protect your hard-earned assets and direct how they will be left behind. Having a will is one of the most definite ways to ensure that your wishes are carried out after you pass on. So if you do not have a will, it's not too late. And if you have a will that's quite old and needs revisiting, it's also not too late to revamp it to make sure it meets your wishes and applies in your circumstances now. So tonight we're going to discuss a number of wills and related estate planning topics, but I remind you ahead of that all information we speak about is of a general nature for information purposes only and is not intended to represent legal advice. So for anyone who has specific questions about their specific circumstances, we'd be happy to work with you and get those questions answered just outside of this presentation in a lawyer-client relationship. So I've tried to put together some of the important questions and considerations that we see when we are going through the estate planning process. And I wanted to give a bit of information about some other interesting points as well. So tonight we'll go over why you should have a will, what making and changing a will involves, whether do-it-yourself will kits are a good idea. We'll answer what is an executor and look at some obligations to other people to include or not include in the will. We'll talk about gifts to minors, charitable donations, marriage as it relates to estate planning, probate, and then powers of attorney. So what is a will? We call it a last will and testament, and that is a legal declaration of a person's wishes regarding the disposal of their property or their estate after they pass away. And the Succession Law Reform Act dictates how your estate will be distributed if you pass away without a will. So if you have a will, you can kind of govern and decide what will happen to your estate. And if you don't have one, then there are certain laws that apply and dictate what would happen. So this legislation, Succession Law Reform Act, gives us a bit of a hierarchy on who will inherit if you don't have a will. And so if that were to happen, it's not necessarily the case that a spouse gets the entire estate. When you look at the hierarchy, there could be people included that maybe you were going to leave out. There could be people left out that you would have liked to include. So if you have any sort of desires like that, then it's important to put your wishes into a will. Having a will lets you choose an executor or an estate trustee, and we'll talk about what that means. It allows you to plan for minors as well. So if you have minor children or there's minor grandchildren and you need to address anything like guardians for them or trusts for them if they are under 18, or if there's RESPs for them, anything like that, having a will lets you put those plans into place. Whereas if you did not have a will, then you don't get a say on any of that. And lastly, it's really important to have a will because it gives peace of mind to will makers and to your families. Okay, so making a will. There are a number of what we call formal requirements to making a will. And generally, high-level overview of those requirements, you need to have your will be in writing, it needs to be signed, and it needs to be witnessed by 2 or more people. So the in writing aspect. If it's not in writing, then it's not valid. So for example, it cannot be a video recording of you explaining your wishes. It has to be written down. The will must be signed and dated, and there's specific rules on where the signature should be. And it's important to note too that the signed requirement does not include electronic signatures. In BC, they are starting to allow will makers to create electronic wills, but here it is to be signed with wet ink. And then the requirement for witnessing. So the will has to be witnessed by 2 people. And those people have to be present all at the same time as the will maker signing the will. And there are special rules about who can be a witness. And generally, they can be anyone who is an adult over the age of majority, and they cannot be someone who's a beneficiary under your will or the spouse of someone who's a beneficiary under the will, right? So when we sign wills at law offices, generally the will witnesses would be the lawyer and another member of the law firm. The Succession Law Reform Act in Ontario does allow virtual witnessing, not electronic signatures, but virtual witnessing, where instead of meeting face to face in person, you can meet with your witness to sign your will by video. But there's certain rules around that as well. And if you are doing a virtual will signing, one of the rules is that one witness needs to be a licensee under the Law Society Act, so most commonly being a lawyer. So once you have a will signed and it's valid and executed properly, you might be wondering how you can make changes. And there's a couple ways. So you could do what we call a codicil, and that's an amendment to your will, or you can do a new will and just start over. And depending on what you're changing, you can figure out which route is best. Codicils, they're legal documents. They amend the contents of a will, they reference the existing will, and then they work together. So that might be appropriate if you are just swapping out an executor or taking out one cash gift to some sort of beneficiary, right? If you are changing the full distribution, that's not something that we would look at doing by codicil. You would likely be looking at redoing a will. Okay, will kits. So you might have heard of these or seen them advertised. Usually a will kit is some form of fill in the blank document, and they're advertised as a cheap way to get a new will without involving a lawyer. But before you opt in or try the do-it-yourself route, there's a lot of risks that you should consider. So like anything done do-it-yourself, the main concern is that the will kit will not have expert advice, right? You're not seeking advice from a professional while you're preparing this will. You're filling in the blanks, and wills really are not a one-size-fit-all exercise. So there's lots of personal factors in everyone's circumstances that are likely not to be considered or factored in if you were to use a will kit. And lots of people will say, oh, my estate or my plans are very basic, right? And everyone seems to think that, but it's not always as simple as you think. And lots of common life situations still need addressing, and certain estate planning techniques are not always available in a will kit. So you get no customization. You are not guaranteed that the will kit is up to date, includes the law that's supposed to be in the will. You lose the benefit of legal advice, most importantly. And I guess lastly too, if the will is fill in the blank and there's any sort of confusing language or ambiguous drafting which could be interpreted more than one way, you might end up in a situation where beneficiaries dispute that, right? And each take a different stance on how the will is to be read, and it could lead to costly disputes or time-consuming litigation as well. So switching gears now a little bit then to what the actual contents of a will are. And one of the most important parts of the will is appointing an executor or an estate trustee. And an executor or estate trustee is the person appointed to take care of the deceased's assets. So they receive the estate assets in trust, and then they administer the estate for the benefit of the beneficiaries named. So having a will is really important because you can choose who this person is. You can choose who will be responsible for the estate. And if you did not have a will, someone would have to apply to the court to take this on themselves. So executors or estate trustees have many important jobs. They're responsible for funeral arrangements or after death care such as that. They will be locating and determining the assets and the debts of the deceased, making sure the debts and taxes are paid, collecting the assets, and then eventually distributing the estate according to the will if there was one. And so choosing an executor is one of the most important decisions in the will, in my opinion. And many people will feel honored to be chosen for that role, but it's important to remember that the job carries a lot of responsibility and obligation. So you really want to choose someone that you trust, who is responsible, and ask them ahead of time if it's a job they'd be considering to take on, because it shouldn't be a surprise to them if you were to pass away and they're named to be the executor. They could decline to act too, right? So it's really important to know that an executor does not have to take on the role. And so to factor in a backup plan is a good idea. So you can name alternate executors. A few of them might be a good idea so that you are contemplating in case someone predeceased you or couldn't take on that role, you have a backup person named. Okay, so after you decide who the executor or the estate trustee will be, then the other biggest piece of the estate planning process is determining how your assets or your estate will be distributed. So are you leaving everything to a surviving spouse? Are you leaving everything to your children? Are you gifting certain cash lump sums to charities or other individuals right off the top, with the rest to pass to the spouse or your children? Are you leaving a legacy by gifting charities certain funds? Are you gifting gifts to nieces or nephews or friends? So a typical distribution might be something like gifting everything to a spouse, and if the spouse wasn't alive, then everything to the children, and if there were no children, on to another plan, or if one of those children wasn't alive but had children of their own, you could have it passed down the bloodline like that. But even in this simple situation, there's lots of elements to consider. So for example, maybe there's trust ages or guardianship for minor children. And once again, those are reasons we steer away from the will kit so that you have advice on those factors. And what we see as gifting under our will as we choose to do, we call this testamentary freedom. So testamentary freedom and the idea or concept is the idea that we can dispose of our estate as we wish, right? And while this is for the most part true, and while our courts do try to honor the wishes of a deceased person, there are some restrictions and obligations sometimes. And so one of those times applies to married spouses. And married spouses have rights if they're not provided for under a will adequately. So one thing I wanted to talk about a little bit were spousal rights under the Family Law Act. And if one spouse dies, married spouse, then the Family Law Act gives the surviving spouse an option. We call it, and the law calls it, an election. And the option that the surviving spouse has is to take what they received under the will from their spouse, or if they died without a will, then to take what they're entitled to by the intestacy laws, or they could elect to take an equalization payment. And an equalization payment is what they would have been entitled to had the spouses separated right before death. So this choice they have is called a Family Law Act election. Do I want to take what was given under the will, and maybe that is everything, to my spouse? Or maybe the spouses didn't leave everything to each other, so maybe it was a smaller gift, or maybe there was nothing at all left to the spouse under the will. And then the spouse who survives would make an election. They'd have to look at the costs and benefits and choose. Do I want to take what is left to me under this will from my spouse, or am I better off really to treat it as if we had separated, and if we would see if they're entitled to an equalization payment. So the surviving spouse would have 6 months after the death of their spouse to make this decision, and they would seek legal advice. They would need to weigh the two options about how much would I be entitled to if I went the separation route, or what am I entitled to under the will. So that's one time where you might have testamentary freedom to gift as you choose under a will, but if a married spouse isn't provided for adequately, then there could be some changes. And another time where we think of testamentary freedom is with adult children. So the laws might dictate that we have to provide for certain people in our wills. And this is the case for dependents. And dependents are those who the deceased was supporting or had an obligation to support immediately before their death. And so that could be different people, but for the purposes of this discussion, I'm going to focus on adult children and not spouses or family members. And maybe you've thought about this, but there's some times where parents decide to disinherit one or more of their children. And the reasons they might think about doing that is for different reasons, really. That could be because of disagreements amongst each other, could be related to lifestyle choices or political views or feelings of being estranged. Or they might feel that these adult children are doing well for themselves and they don't need the money. So a question we sometimes would get is, can my adult children, if I've not left them anything in the will, can they argue that? And if that conversation comes up, that's something we need to dive into a little bit deeper with our clients. The Ontario Court of Appeal has confirmed that generally there's no legal obligation to leave anything to an independent adult child over 18, an independent child. But if an adult child was financially dependent on the deceased parent just prior to the parent's passing, then this child could be considered a dependent and they might be successful at making a claim against an estate. And in Ontario, there's a concept called dependent relief, and a few different pieces of legislation, including the Family Law Act and the Succession Law Reform Act, discuss obligations to provide financial support to certain family members. So if a will maker dies without leaving adequate support to their dependents, then those people entitled to support could make a claim for dependent relief so that the estate pays them before paying the beneficiaries that are named. So you might be thinking, well, who can claim dependent relief? And that depends on the meaning of dependent. And one type of dependent is a child, but being an adult child is not enough to entitle them to support or to entitle them to a gift from their parents under their will. So to be a dependent, the child would have to be receiving or be entitled to receive support from the deceased parent immediately before their death. If they're minor, that's one thing. If they're not a minor, but were entitled to support from their parents or were receiving support from their parents already, then they could be an adult dependent of that parent. So for example, in the case of a child who is unable to support themselves due to medical issues, they might be entitled to receive a portion of the parent's estate. And the courts will look at a number of factors for the person seeking relief to make that determination. And if an adult child is not a dependent of the parent and is fully independent, then in Ontario, will makers still have the freedom to decide who to include in their will, and they could choose not to provide for their adult independent children. And I should note though, so this ability to cut off a child entirely can vary by jurisdiction. So for example, in British Columbia, there have been disinherited children who have successfully sued to get something from the estate. Switching gears a little bit again, an important consideration under wills is minors. So if we're gifting anything to a minor, we need to look at whether we're holding their funds in trust. Because in Ontario, a minor child under 18 is not able to inherit funds directly. So there's a few different options to address what can happen instead. And one of those options is that the will can create a trust for the beneficiary until they're an older age. And if a will contemplates a minor child and creates a trust, then the will would specify who the trustee is. So it could be the executor, it could be anyone else, but you would name a trustee over the minor child's funds to hold them, and the funds would be used as the will describes. So if you're talking about minor children and making a will, you might be thinking about what age will this minor child be entitled to their share of the estate? Do they get it at 18 or something like 21 or 25 or 23? Do they get it in stages at different ages? And we could also look at giving discretion to the executors or the estate trustees to release those funds to the other parent or guardian of a minor child rather than keeping a trust ongoing for years and years. Something else that people like to look at sometimes in their will estate planning is charitable donations. So you might be thinking of causes that are really near and dear to your heart and be wanting to include those in your plans. So some of the specific considerations when we're talking about charities are Are you gifting a lump sum payment to a charity no matter what, no matter who's alive, or are they only getting something as a backup plan? Are they only inheriting if your spouse and kids and grandkids are not alive, then the charity you've named is a backup? Are they going to include specific organizations that you've chosen, or are you giving your executor or estate trustee the ability to choose the charities that you want, that they think you should benefit? And then do you plan for a situation where the organization might not be around? So if you passed away and named a certain charity and they were no longer there, will you let the executor pay that gift to the successor organization or to the nearest organization that's most similar? So those are just some of the considerations around gifting to charities. Marriage is another interesting topic in relation to wills. If you've got blended families, then there are other specific considerations in the will drafting process that make it important to seek legal advice rather than just using a will kit. But something interesting about marriage is that prior to 2022, getting married actually revoked or canceled a will. So, for example, if you made a will in 2015 and then got married in 2020, your will from 2015 was made invalid. It no longer applied. And it would, if you passed in 2021, it would be as if you passed without a will. And the idea behind this legislation saying a marriage revokes a will was that if you got married and you had a past will, once you were married, the will probably didn't include this new spouse. And so if the marriage canceled the will, then the intestacy laws would allow the spouse to have some entitlement. So I think that was the idea behind it, but we have now revoked that legislation so that marriage doesn't revoke a will anymore. It's not retroactive though, so still, if that example applies, if you made a will in 2015 and you got married in 2020, the will was revoked. If you made your will in 2015 and you got married this year, the will is not revoked because the marriage occurred after this change to the legislation. And one more note about marriage in relation to wills is that if you've appointed your spouse as the executor or you've gifted to them under your will and then you've later divorced, those appointments and those gifts are canceled, and the laws have changed a little bit again to factor in separating spouses in case you haven't fully divorced. So now it applies to them, and there's certain rules around that, but it's getting a little bit broader there. Switching gears then just to probate, because this is an important process and one of the reasons we make a will to start. Probate is the process of applying to the court to confirm that the will of the deceased person is valid and it's the last official will of that person. And we call it probate for short. It's the appointment of an estate trustee with or without a will, and you get what you call a certificate of appointment when you receive probate. We still just refer to it as probate because it's a bit simpler than all of that language. But seeking probate is asking for the court's approval that the will is the last will of the deceased person. It's valid. The estate trustee named is the person who has authority to manage and distribute the estate, and they have the power to act as the estate trustee. And probate is not always necessary, but it'll be necessary in certain circumstances. So if one dies without a will and you need to have an executor appointed, you're going through the probate process. It might be needed if a financial institution requires proof that the estate trustee actually has authority to manage the deceased's finances or affairs. If there's real estate that needs to pass from the deceased, then except for limited exceptions, there is likely the need for probate. And there's a few other reasons as well. But as soon as you have to make an application for a certificate of appointment of estate trustee with or without a will, or probate for short, then the estate is looking at paying estate administration taxes on the value of the estate. Lastly, I wanted to touch on powers of attorney. So leaving the will behind, the will will govern what happens when you pass away. Powers of attorney apply before that. They apply while you're living. And if you passed away, they become invalid. And there's like two types of powers of attorney. So these are legal documents that give people the authority to manage your affairs under certain circumstances. They can be temporary for specific purposes or for limited periods of time, or they can be continuing. And the two types are property powers of attorney and personal care powers of attorney. So a property power of attorney names someone to manage finances, selling or buying real estate, managing bank accounts, paying bills, dealing with your investments. And the personal care power of attorney is about managing personal and healthcare decisions. So medical treatments, healthcare decisions, shelter, nutrition, clothing, those sorts of things are covered by personal care power of attorney. And for personal care power of attorney, those decisions are only made by the people you've named when you are mentally incapable of doing so for yourself. Okay, so what can your power of attorney or your attorney do? They are there to make decisions in your best interests. They don't own your property, they only are given authority to manage it. And absent any limitations that you choose to incorporate into your documents directly, the attorneys can do almost anything that you could yourself, except for things like making a will or changing beneficiaries on your designated plans. But otherwise, powers of attorney can make decisions as you would. And these are important because they'll make sure your property is taken care of in the case that you lose ability to do so. And you can only make these documents and appoint people while you still have the mental capability or capacity to do so. So if you are too far into stages of dementia, or you end up in a coma or something like that, you might be too far gone to actually appoint people. And then you're looking at different, more complicated routes of having a decision maker appointed for you. So it's important that you can make these choices and name people who you want to step in while you are able to actually complete these documents. Who can you designate? So this is a personal decision. You want to keep in mind that it should be someone that you really, really trust. Will the person be able to handle responsibility of managing your property and your personal care? And would they agree to take this on? So a number of factors to consider when you're naming people as powers of attorney. And there are age requirements on the people you've named as well. So to be named as a POA for property, then the person has to be at least 18 years old. And to be a power of attorney for personal care, the person you've named has to be at least 16. And you can designate more than one person. It doesn't have to be someone on their own. Again, we would name alternates usually in case that person ahead of them in line can't act, or they've predeceased you, or they decide they don't want to take that on. And you can name people together, jointly we call it, or jointly and severally, so that one can make a decision if it came down to not both being able to do that. So that's all I have for you tonight. I hope that was high level, some interesting facts and points about estate planning.
Thank you so much, Megan. I do actually have some questions here, if you don't mind.
Sure.
Thank you. So, for example, do we need to register that will on any government bodies or with any institutions, or just having it signed, witnessed by two witnesses would makes it valid?
That's right. There's no registration requirement. And it might seem helpful if there was, so that they're findable. Sometimes there's difficulty locating a will of a deceased person if there's not a central registry, right? But no, there's no requirement to do that. And so once it's signed, dated, witnessed, and formal requirements are complete, then the will is valid and it doesn't need to be registered anywhere.
Thank you so much. So would the notarization of the will, or what usually then notaries would add, the affidavit of execution, would it has any value added to the will? Would it makes it better, more acceptable?
Okay, so the question is, if there was an affidavit of execution, is it more valuable?
Yeah, for example, let's put it that way. If I notarized my will, would that make any value added to it or not?
So I think people use notarizing in different contexts. There's no need to notarize a will, right? Once it's actually signed with the proper witnesses, it's valid and it can be relied upon. The affidavit of execution that goes with it is a document signed by one of the witnesses to say, I swear I met with this will maker. They signed the will in the presence of myself and the other witness named so-and-so, and I confirm that I saw the will signed in the presence of both witnesses, right? And that is an important value add piece because if you need to go through that probate process, you submit the original will to the court and they will need an affidavit of execution with it. So that sworn statement by one of the witnesses to say, I saw this will get executed properly. And so if the will is done and there's no affidavit done at the same time or right after the will signing, and someone passed away and 20 years later you found the will, but you don't have an affidavit from one of those witnesses, then yeah, it can get tricky because you have to hunt down witnesses from that many years ago. And if you can't find them, then there's other complexities. So that piece, having the affidavit after it's signed is a value add, I think.
So the point behind that question is sometimes because as you know, the notary need to verify the identity of the person who's signing the document before notarizing, and that notary would testify that this document is signed before me in such and such. So maybe this would be value added in order to prove the will itself, not for the substantive elements of the will. So the will itself is valid, but as you know, the main rule, it does not matter what happened. What's really matter what we can prove.
Yeah, and I think the notary piece too is, you're right in that someone notarizing, making a notarial copy of the will, you see the original, you see the affidavit, a notary could make a copy of that and say, I swear this is a notarial copy of the original that should be treated as original, right? So sometimes that's helpful for institutions or someone looking for the original, but you don't want to give away the one and only original.
Thank you so much. We do have a question. Actually, I've been asked this by so many. It might be not directly related to this, but to some point, maybe if you can answer that, that would be great. There is a common say between people, especially when they're exchanging information based on word of mouth, that, well, if you don't have a will and there is no guardian for your minors, then the government will take them. Is that right?
So there's a court process for having a guardian appointed, and having a will is a much cleaner way to name the guardians that you would like to see in charge of your minor children. And to avoid going through a court-appointed guardian, then definitely make a will to make your wishes known. There's different stages to that, and I think that's kind of a larger question, but I would say that even when you put a wish into your will to say who you want to be the guardian custodian of a minor child, that those are just indications of your wishes, and a court could always change that. So they're going to always look at who's in or what is in the best interest of a child. And if they think the person you've named as guardian is not the best choice, or they will not be acting in the best interest of a child, they could appoint someone else. So I think, as long as you've appointed someone that is reasonable, if you've named a sister and now the sister is living on the street, for example, then the court would probably step in to say, that's not in the best interest of the child, let's look at someone else.
That make sense. Okay, so I'm just taking a final look to see if we do have any questions from different social media platform we are broadcasting on. So If you have any question, please feel free to type it to the chat. Okay, well, at the end of this very informative, straight to the point, direct presentation, I would like to express my great thanks to Megan Jenner and to Cohen Highley Lawyers for their kind help and support. It's always an honor to have you on RRAI platform. Thank you so much.
Thank you as well. Pleasure to be here.
Thank you everyone for being here tonight with us. And as always, we're looking forward to see you at another sessions with Rights and Responsibilities Awareness Initiative. Stay well, stay safe, and have a great rest of your day, everyone. Bye-bye.